I would also like to stress that all countries which are able and willing to contribute to this cause should be welcome to do so. We are pleased that the contributions made by countries like Iran to fight piracy off the coast of Somalia have been well recognized and commended by the international community and relevant UN bodies, including the Security Council resolutions 1950 and 2020. Madam President, the crime of piracy is clearly defined under international customary law. Therefore, fighting piracy should be carried out in accordance with international law, and here I would like to refer to paragraph 90 of Resolution 66/231 of the General Assembly, which stipulates that resolutions 1816, 1838, 1846, 1851, 1897, and 1950 from 2008 to 2010 apply only to the situation in Somalia and do not affect the rights, obligations, or responsibilities of member states under international law, including any rights or obligations under the Convention, with respect to any other situation, and underscores in particular the fact that they are not to be considered as establishing customary international law. Regarding the marine environment, Madam President, it goes without saying that protection of marine environment is vitally crucial in safeguarding the health and well-being of human beings. Unfortunately, pollution at seas and oceans has reached to an alarming level, and the international community cannot afford to pay very high prices for the consequences. One important issue among others is the problems caused by land reclamation activities. My delegation would like to draw the attention of distinguished delegations to the United Nations expression of deep concern at the adverse economic, social, and environmental impacts of the physical alteration and destruction of marine habitats that may result from land-based and coastal development activities, in particular those land reclamation activities that are carried out in a manner that has a detrimental impact on the marine environment. In this regard, the United Nations General Assembly has repeatedly, I quote, called on all states to ensure that urban and coastal development projects and related land reclamation activities are carried out in a responsible manner that protects the marine habitat and environment and mitigates the negative consequences of such activities. We call on the Secretariat to include this important issue in its next report on the agenda item. Regarding the marine biological diversity, Madam President, my delegation has followed the proceedings of the sixth meeting of the ad hoc open-ended informal working group to study issues relating to the conservation and sustainable use of marine biological diversity beyond areas of national jurisdiction, which took place in New York from 19 to 23 August 2013. For the past several years, there has been various workshops, events, and meetings on this key issue, and different views have been expressed by member states regarding how best to manage the use of marine biological diversity at high seas in a sustainable manner while ensuring its conservation. As it has been observed during the debate of the working group, and which is reflected in paragraph 89 of the summary of proceedings prepared by the co-chairs of the working group, I quote, "The fact that discussions among states were ongoing regarding the need for legal regime for the conservation and sustainable use of marine biodiversity beyond areas of national jurisdiction attested to the concerns of many states over regional or cross-sectoral approaches and initiatives, end of quote. In this regard, my delegation is of the view that these resources fall under the legal regime of common heritage of mankind, and as such, the provisions of relevant part of the UN Convention on the Law of the Sea shall be applicable to their use and conservation. We hope that all states cooperate in a spirit of common responsibility to reach an agreement on the legal regime applicable to the conservation and sustainable use of marine biological diversity beyond areas of national jurisdiction. Thank you, Madam President.
Thank you, Iran, for your statement. The next delegation on my list is Japan. Japan has the floor.
Thank you. Madam President, Japan as a maritime nation and from the standpoint of regarding the rule of law essential in the international community, highly values the roles that the International Tribunal for the Law of the Sea, ITROS, has been playing for the peaceful settlement of maritime disputes and the maintenance of legal order relating to the sea. It is noted that in recent years, the number of referrals of cases to the ITROS has been on the steady increase. This reflects growing recognition and trust by the international community towards the ITROS as competent dispute settlement organ. Furthermore, most recently, we have seen important developments, as just mentioned by the Deputy Director General, such as the ITROS delivering a judgment on the dispute concerning the delimitation of the maritime boundary between Bangladesh and Myanmar in March 2012, and also the ITROS receiving a request for advisory opinion from a sub-regional fisheries commission of West African countries. This trend is a clear evidence of growing recognition of the role of the ITROS on the part of Asian and African countries and the international community as a whole. We welcome greatly the increasing trust and confidence by the international community for the activities of the ITROS. Madam President, from the outset of the establishment of the ITROS, Japan has been fully cooperating with it as the largest financial contributor, as well as provider of valuable human resources, including many competent judges. We will continue to render maximum cooperation so that ITROS will be able to fulfill its activities under the leadership of President Shunji Yanai more effectively to respond to the growing trust and expectations of the international community. In 2014, there will be an election of judges during the 24th meeting of state parties of ITROS, and the Japanese government decided to nominate Judge Yanai as a candidate. We are confident that Judge Yanai, if re-elected, will, with his fair and sincere character and competence, make further contribution to ITROS activities and the advancement of maritime legal order. Madam President, next, I'd like to refer to the work and constraints faced the two important organizations relating to the sea, that is the UN Commission on the Limits of Continental Shelf and the International Seabed Authority. The UN Commission on the Limits of Continental Shelf, which is in charge of the task of examining and making recommendations on the submissions regarding the outer limits of a continental shelf beyond 200 nautical miles by state parties pursuant to UNCLOS, has been continuously confronted with the serious workload issue caused by a large increase in the numbers of submissions, which has to be discussed by the state parties of the Convention on the Law of the Sea. Until present, while 66 submissions have been made, only 18 recommendations were issued. One of the practical ways to reduce effectively the said workload is to lengthen the working period of the members of the Commission. Japan has been contributing to the trust fund established for the purpose of defraying the costs of participation of the members of the Commission on the limits of the continental shelf from developing countries in the meetings of the Commission 6 times, totally $1.44 million. Similarly, with regard to the International Seabed Authority, there has been established a voluntary trust fund for the purpose of defraying the cost of participation of the members of the Legal and Technical Commission from developing countries and the members of the Finance from developing countries in the meetings of the Commission and the committee held in Jamaica. At the recent 19th session of the Assembly of the Authority held in Kingston, Japan announced that it will make a contribution to the fund in the amount of $44,760. Thank you, Madam Chairman.
Thank you, Japan. I'll give the floor now to Tanzania.
Madam President, consideration of this topic comes at the time when we are commemorating the 30th anniversary of the United Nations Convention on the Law of the Sea. The importance of UNCLOS in regulating ocean affairs cannot be overemphasized. Note with appreciation the 4 topics which were extensively discussed during the legal expert meeting to commemorate the 30th anniversary of the UNCLOS in March year 2013. The topics which were deliberated in that meeting, namely, dispute settlement mechanism under UNCLOS, preservation and protection of marine environment, piracy, and UNCLOS and ALCO forms the very core of the spirit of the UNCLOS seeks to uphold. We, as legal experts, should take deliberate efforts to uphold the principles and mechanisms which are contained in the Convention in promoting ocean governance. Piracy. The 2 continents have witnessed a notable achievement in reduction of the number of successful piracy attacks. However, in order to make this success sustainable, states have to make concerted efforts, particularly in strengthening their legal framework and enacting legislations where there are none. Furthermore, strengthening cooperation in the region, particularly in the information sharing, is of utmost importance. Member states should continue strengthening alliances and cooperation within the already existing fora, such as within the framework of the Djibouti Code of Conduct and Contact Group on Piracy off the coast of Somalia. Madam President, workload of the Commission on the limits of the committed shelf. As we all know, due to the growing number of submissions, the Commission continues to face a major challenge in examining all submissions and provide appropriate recommendations. In making an effort to alleviate the work of the Commission, Tanzania is of the view that ALCO states should collaborate with other UN member states, take concerted efforts to ensure that the Commission continues to undertake its duties smoothly. In this respect, as echoed in the 20th session of States Parties, Tanzania strongly encourages member states to solve amicably disputes relating to their submissions.